Ready?
Yep.
Okay. Well, good afternoon, everybody. Welcome to New Laws for Contra Costa County Bar Association Criminal Law Section. I'm excited to be here and thank you for the introduction, and we're going to have a good time today. Couple of things before we start. One is, was already mentioned, I'll take questions as we go, put them into the chat feature. If I don't notice them, hopefully someone will tell me, hey, there's a question here. Secondly, I understand that many of you may have attended this similar presentation that I gave for the CACJ, California Attorneys for Criminal Justice, on December 5. This program there'll be a lot of overlap, but there'll be a lot that's different, because I've been refining this presentation as I go, particularly on the probation and on the three-tiered registration. There's differences throughout. So pay attention, everybody. Okay, so
let me introduce you, Garrick. Not that you need an introduction, most of us know you, but okay. Everybody, welcome to the first 2021 Criminal Law Section event. I'm Ashley. I am your new Criminal Law Section President, and I'm really excited to be starting off with such an excellent first MCLE. As Garrick said, this is the new laws of 2021. Now, most of you already know Garrick Byers, the statute decoder. He is a noted writer, speaker, and litigator in California criminal law. Every year, he web publishes an 80-page treatise on new laws. He writes 3 chapters in the CEB's California Criminal Law Procedure and Practice, and has spoken at several CEB criminal law webinars. He coordinates and speaks at the California Public Defenders Association's annual MCLE activity, New Statutes, and is a former president of CPDA and is on their legislative and ethics committees. He has spoken at tens of MCLEs for CPDA and is certified by the California State Bar as a criminal law specialist. He recently has handled many felony murder resentencing cases under SB 1437 and Penal Code 1170.95 with the Solano County Public Defender, and is currently handling court-appointed indigent appeals and does case consultations. So thank you so much. This is where I would have you all welcome him with me, but he'll just have to know that you are welcoming him from the other side of your screens. As he said, put your questions in the chat and I will make sure that they get to him. Thank you so much, Garrick, and take it away.
Hey, that was great. I wish I had waited for that introduction. Thank you very much. Okay, so by the way, we're also, one other thing, this meeting's being recorded, so smile. Okay, goals for today. Tell you about some major new statutes, rules, and forms for 2021. This is mostly a memory jogger. There are some new forms I'm going to tell you about towards the end that you want to use those forms. But this is mostly a memory jogger. There's too many new laws. They're too detailed, and the major ones are incredibly detailed. And so you're not going to be able to remember them all. I can't go into them all. But what'll happen as you go through your daily practice over the year, you'll remember them. Your memory will be jogged. Hey, the statute decoder talked about that. I'd better go look it up. So that's what this is all about. Trends this year, the major new statutes emphasize racial and ethnic and similar prejudice in jury trials, try to cure those. There's new standards for the use of force by police officers. And there's also emphasis on making some criminal convictions less onerous than they ought to be in terms of fees and probation length. There are very few new crimes this year. And vocabulary-wise, an increasing number of new statutes. I substitute they and their instead of he or she and his or hers and the like. Just remember that Penal Code Section 7 says that the plural includes the singular. So you can't say, well, this says they can't do that. My client is singular, doesn't count. Yes, it does count. Okay, so let's start right in. Probation length of terms. Those of you who have heard this before, This is somewhat different than what you've heard before because I add a lot of permutations of what can happen. All right, so it is AB 1950 is the law. Now, the way I've done these slides is I usually have the statute, the bill on the side, on the left side, the statute number, the chapter number. What you want to pay more attention to is what's usually on the right side, the statutes that it amends. In this case, it amends 1203.1 and 1203A. Very difficult to find in the codes. I'll talk about that. So under 1203.1, the maximum length of felony probation is reduced from 5 years down to 2 years, except for offenses that provide for longer terms of probation. And these are down in subdivision M, way down at the bottom of 1203.1, which leads you to an important rule about reading statutes. Read them all, read the whole thing, because very often what you're really looking for is buried in the middle, or in this case, has been put way down at the end. And if you don't read the whole thing, you might miss what's most important. So the exceptions are way down in M. Violent felonies, 667.5 subdivision C, which probation can last up to the maximum length of the sentence, or offenses that state a particular probation length. I'm going to go into that. And certain theft type offenses where probation can be up to 3 years. Okay, so, and then misdemeanors, 1203A, maximum length of misdemeanor probation is reduced from 3 years to 1 year, unless the offense provides for a longer term. I just put in a little bit about how to find them, because this 1203 series is incredibly complex, just absurdly complex. We may get a revamp of those sections of the penal code in a couple of years. And codifications differ. They're not an official codification really, but usually in most of your codes, 1203.1 comes after 1203.099 and before 1203.1A, just to help you look for it. 1203A is different than 1203 subdivision A. That usually comes after 1203.14 and before 1203B. Usually takes me a long time to find these in the codes. Okay, now exceptions. There's exceptions, and in terms of the number of cases, the exceptions may actually outnumber the new rule. So you always got to check the relevant statutes. But the two main exceptions, I think, are in domestic violence. 1203.097 subdivision A basically says that all domestic violence, as defined in Family Code 6211, those of you who do a lot of domestic violence stuff, you might want to just take a Family Code 6211 and the surrounding statutes, paste them in your book, or put a page in there, because there's a lot of DV cases, not just 273.5. At any rate, all of them have a maximum, a minimum probation length of 36 months. Now, the second, probably the major exception, is DUIs. Almost all the DUI statutes under VC 23600 subdivision B1, the probation length has to be not less than 3 and no more than 5 years. So there's lots of exceptions to this. Okay, length of term. So here's a bunch of questions. These weren't in the CACJ materials. So does this apply to a case that was charged before January 2021, but wasn't sentenced until after that, or was sentenced after that, but it's not yet final on appeal? The 60 days hasn't elapsed, or it's up there in the Court of Appeal or whatever. And the answer is yes, it is retroactive. There's 3 cases. People versus Sims just 10 days ago, People versus Quinn 11 days ago, People versus Burton last November. And by the way, these 3 cases are also useful for showing that probation is punishment for this purpose. And we'll get into that a little bit. So, all right, suppose the defendant is on probation, the appeal time has lapsed, and the defendant is in compliance with probation. Is the defendant's length of probation automatically shortened so that the defendant can stop reporting? And the answer is, I think that relief is not automatic on this. There are people who disagree with me on that. My advice is file a petition anyway. Even if you think it is automatic, file a petition anyway, because if it wasn't automatic, and your client says, oh, it's automatic, I'm going to stop reporting, I'm going to stop paying, I'm going to do this or that, you may find your client has a violation of probation they can't get out of. So file a darn petition. But there's a case, People versus Banks. It's a 1959 case. By the way, written materials, as mentioned, written materials that get sentenced out, all these cases are cited in there. In that case, in this 59 case, so the defendant is eligible to get his conviction reduced, restore his right to have guns. He doesn't get it reduced. He has a gun. He gets charged with felon in possession, and he gets convicted. On appeal, he says, hey, wait a minute. I could have gotten that thing reduced and dismissed, so I shouldn't be convicted. And the court said, no, you were a convicted felon at the time that this arose. And so the fact that you later got it expunged or dismissed doesn't make a difference. What makes a difference is your status at the time. So don't take chances on this one. Okay, so can the defendant go back to court, have the term shortened? And can the court reconsider all the probation terms? This is one of the reasons that I think that this is not automatic. I think the court can juggle around those probation terms. So there's three cases, none on point. People versus McKenzie, People versus Chavez. Those are California Supreme Court cases. People versus Barton, a Court of Appeal case. These cases basically, in my view, those three cases can be cited to show that your client can go back to court, can get the probation shortened, but the court may want to change some of the terms and conditions. I do not believe the court can give a longer term, a more onerous term maybe, but can't, for example, send to prison or jail. For example, suppose your client got a fine. Your client's been paying it in installments. The probation charge the length of probation gets reduced. I don't think that truncates the fine. I think the court can jiggle around and say, well, I'm going to change the fine. You have to pay faster, or maybe I'm going to reduce it. But I think you have to go in and get it done. How about if they were charged with a violation before January 1st? Can they, and a bench warrant was issued, probation was summarily revoked. Can they defend that on the ground that probation would already have expired prior to the alleged violation of probation? I think they probably can't, but this is a close call, and you can certainly defend it on that basis. But here's the cases that are against you. Banks, I talked about earlier, there's a case called People versus Leiva, if I pronounce it correct, L-E-I-V-A, California Supreme Court, which addresses the court's jurisdiction to adjudicate a violation of probation on which bench warrant issued, probation summarily revoked, and then after that, the probation term expired or would have expired. Can the court go back and do that? Usually the court can under that case. So you want to look at those cases and overcome them if you can. Okay, well, let's go to this one. Many criminal fees are eliminated now. This is a new subject. This is cool. It's mostly operative July 1st, 2021. So I'm going to talk to you about what to do between now and July. Main thing I would do is I'd remember every day is getting closer to July. What this does is it repeals about 23 categories of what the statute, the legislative history calls criminal administrative fees. Public offender fees, public defense fees, appointed counsel, even appointed private counsel or conflicts counsel. That's you guys. It repeals various statutes associated with criminal justice administration. It does leave in place that $40 court construction fee. It does leave in place a particular criminal conviction fee, but it eliminates a whole bunch of others. It eliminates a lot of fees associated with work furlough, with home detention, with electronic monitoring, with county parole supervision. Now, it does not eliminate all the possible fees, but it does eliminate a lot of them. It eliminates probation investigation fees and progress reports fees. Here's the way I would approach this. When you get to sentencing, hopefully you get your probation reports ahead of time and you can do this ahead of time. But if you don't get it until the day of sentencing, you say, hey, judge, they assessed a lot of fees. I need to find out if they're still valid. Okay, look up the fees, any fees, and see if they got eliminated by this. And your quickest way to do it might be to check out PC 1465.9. This is another one that comes way at the end of a series of statutes, all called 1465, 1464, whatever. So on and after July 1st, 2021, the balance of any court-imposed costs, it doesn't say your client gets a refund. It does say the balance. Pursuant to, and then it lists a whole bunch of statutes, 987.8, 1203, 1203.16, on and on, as they read the day before, June 30th, shall be unenforceable, uncollectible. Any portion of a judgment relating to those costs shall be vacated. So what can you do? Well, you can, if you can't just delay for the sake of delay, mind you, but if you can set your sentencing after July 1st, that will be easier for you to deal with. If it comes before July 1st, hey, judge, this fee is going to get eliminated on July 1st. My client can't afford to pay it. Or can we just assess the normal fee thing? Don't make them try to pay in advance. I think you'll do all right on those. All right, the California Racial Justice Act. Those of you who got my criminal law treatise before this, I'm going to send out a new one that emphasizes this more than I did originally. I have come to think that this is the main, this law has the biggest potential of all the new laws this year to really change things. It adds Penal Code Section 745, and it amends the habeas corpus statute 1473 and the sort of quasi habeas corpus for non-citizens 1473.7. So here's PC 745 subdivision A. The state shall not seek or obtain a criminal conviction, shall not seek or obtain or impose a sentence on the basis of race, ethnicity, or natural origin. This statute doesn't cover several other suspect categories or quasi-suspect categories, gender, sex, orientation, that sort of stuff, just race, ethnicity, national origin. So a violation is of 745, seek, obtain, or impose because of these, is established if the defendant proves by a preponderance any of the following. That the judge, an attorney in the case, a peace officer involved in the case, an expert witness, or a juror exhibited bias or animus towards the defendant because of race, ethnicity, national origin. Now, a lot of these terms are defined. We'll get to definition section. And two, during the trial, in court, during the proceedings, the judge, an attorney, a cop, expert witness, or juror used racially discriminatory language about the defendant's race, ethnicity, national origin, or otherwise exhibited bias or animus towards the defendant because of race, ethnicity, national origin, whether or not purposeful. That seems like it's going to be quite a powerful statute. It's certainly going to be the easiest one of these to enforce. What's the difference between 1 and 2? Well, 2 has to occur during trial. It adds language, whether or not purposeful. Frankly, I'm not entirely certain what the difference is between 1 and 2, and that litigation is going to occur over that. Obviously, you didn't have a juror and a defense and a judge before that, but you can file a pitches based on racial animosity of the officer, so you can try to apply this before the case is filed too, but it certainly applies after the case is filed. All right. Now, number 2, what happens in court, it doesn't apply if the speaker is describing relevant language used by another. You know, this person used a racial slur. Well, that doesn't mean that the speaker has been discriminatory or is giving a racially neutral and unbiased description of a suspect, but mostly it applies. Okay, now 3 and 4, these are going to be difficult to prove, but they're probably actually the main kind of discrimination that goes on. So the defendant is charged or convicted of a more serious offense than defendants of other race, ethnicity, national origin who committed similar offenses and are similarly situated. And the evidence establishes that the prosecution more frequently sought or obtained convictions for more serious offenses against people who share the defendant's race, ethnicity, or national origin in the county. So this is going to require statistics or some kind of really heavy duty proof, ongoing type of proof, and looking at past cases. It's why a lot of this is going to come up on habeas corpus, and we'll talk about that. All right, 4, it seems similar. You got to look at it closely to figure out the difference. But this one has to do with sentences. 3 was charges. 4 is sentences. Longer or more severe sentences imposed on the defendant than on other similarly situated individuals convicted of the same offense, and longer, more severe sentences are more frequently imposed on people that share the defendant's race, ethnicity, national origin than on defendants of others in the county. So again, it's the two-part, this case and a lot of cases in the county, not just the state, in the county. B is somewhat the other side of the coin on this one. A longer or more severe sentence is imposed on D than was imposed on other similarly situated individuals convicted of the same offense, and longer or more severe sentences are on the defendants of the same in cases with victims of more than of one race, ethnicity, national origin than in cases of victims of other race, ethnicity, national origin. In other words, the cop gives all black, the judge gives all black defendants a more severe sentence than all white defendants, or the defendant gets a more severe sentence if all the victims are white, as opposed to the victims being black or whatever. That's the kind of illustration, but it's pretty broad, really. So how's this proved? Okay, so that's B. A was what are the violations. B, how's it proved? So the defendants can file, and this is not really a retroactive thing. The trial's got to be held after January 1st for this to apply. Jury picking has to occur after January 1st for this to apply. So you can't go back to a case that's already been done. No, judgment. Okay, this act applies only prospectives in cases where judgment has not been entered prior to January 1st. If your trial's been concluded in December, but judgment hasn't been entered until after January, this is going to apply. I just slightly misspoke a minute earlier. Hey, this is being recorded. Maybe that can be edited out. Anyways, here's what it is. At subdivision J, way down in buried in the statute, like I said, if your judgment hasn't been entered, you can look back at your trial and see. All right. So what happens is the defendant files a petition. Now, if judgment passes, judgments occurred January 2, first day back, you can file a petition for a writ of habeas corpus. Now, the reason why habeas corpus has been changed is this. These more complex ones, 3 and 4, they're going to require an assembly of statistics, getting experts, taking time to assemble the evidence for it. And so that's why you can do this by habeas corpus. Same thing with if the non-citizen can do this under 1437.7. Okay, so if the motion is filed, the statute doesn't say the motion has to be in writing, but boy, I sure would put it in writing. If you want to make it verbally, fine, but say, Judge, I want a chance to put it in writing. If a motion is filed in the trial court and the defendant makes a prima facie showing it's defined, the trial court has to hold a hearing. At the hearing, evidence can be presented by either party, statistics, aggregate data, expert testimony, witness testimony. The court can appoint an expert. The defendant has the burden of proof by a preponderance. The court has to make findings on the record. The court can't just say motion denied, counsel, let's move on. The court has to make findings on the record. And there's a discovery statute, that's D. The defendant can move for disclosure of all evidence relevant to a violation in the possession or control of the state. It can't be a fishing expedition, has to describe the type of records or information sought. That records or information says to me it doesn't have to be written down, but it can't be a fishing expedition. Upon a showing of good cause, the court has to shall order the records to be released. All right. Now, notwithstanding, so what are the remedies? So I found a violation, I proved it. What are the remedies? So notwithstanding any other law, except a voter passed initiative, you might look for that. If the court finds by a preponderance there's a violation, the court has to impose a remedy from the following list. If this is done before judgment is entered, the court can declare a mistrial if requested by the defendant. There's a misprint in the statute. If requested by defendant. Look, they all make mistakes, folks. can discharge the jury panel and panel a new jury. If the court determines that it would be in the interest of justice, it can dismiss enhancements, special circumstances, special allegations, or reduce charges. This is a controversial one. I'm sure the prosecution is going to say, hey, charges is the prosecution's job, not the judge's. I'll bet this holds up, but we'll see. All right, after judgment, if the court finds that a conviction was sought or obtained in violation, the court has to vacate the conviction and sentence and order new proceedings. If the only violation is greater charges, and the court can rectify it by modifying the judgment, the court can do that. If it was only the sentence, and the court can remedy it by imposing a new sentence, but not a greater one, the court can do that. Okay, so there's a bunch of definition. Now, first of all, if there's a violation in a death penalty case, the defendant's not eligible for the death penalty anymore. I don't know if that applies on a new filing, a new jury, but it certainly applies in that same case. Other remedies can be pursued. Now, this applies also to juvenile delinquency cases. And there's a bunch of definitions of more frequently sought or obtained, more frequently imposed. What is a prima facie showing? Racially discriminatory language means language that, to an objective observer, appeals to racial bias, and then it goes on. And this in state doesn't mean just a county DA, attorney general, city prosecutor. Okay, and the defendant can have more than one race, ethnicity, or national origin. Okay, so that's the Racial Justice Act. Okay, so better than Batson Wheelson, Now, this statute does not become effective until jury trials that begin on and after January 1, 2022. So I'm not going to go in huge detail on this. I'm going to go over this fairly fast, which I've already done, by the way. But the reason I want to bring it up now is, one, so that you can prepare for it, because some of your trials are going to take this long to prepare, but two, some of this one contains lots of information, lots of statutory sections that are actually going to be useful in RJA cases, Racial Justice Act cases. So a party shall not use a peremptory challenge to remove a prospective juror on the basis of race, ethnicity, gender identity, sexual orientation, national origin, religious affiliation, or perceived membership in any of these groups. Now, this is a whole lot. The reason this is, I call this, first of all, I got the part of the title from Elizabeth Semmel, but at the CHCJ seminar, I added Wheeler, better than Batson Wheeler, because it's easier to show the violation than the original Wheeler case, than the Supreme Court's Batson case. For the trial court on its own motion, so the trial judge can bring this up, can object to the improper use of a peremptory challenge by either the prosecution or the defense. Prosecution can use this. The objection has to be made before the jury is impaneled, unless the information becomes known that could not reasonably have been known before that. For example, midway through the trial, somebody comes up to you and says, hey, that juror is all kinds of prejudice, and here's how I know. So that's information that couldn't be known. You can make that challenge, even though the jury's been selected. Upon objection to a peremptory, the party exercising the peremptory has to state the reason. So you don't have to convince the judge anymore that you've made a prima facie case on your objection. You make the objection, the party's got to explain it. All right, the court has to evaluate the reasons in light of the totality, and the court can only consider the reasons actually given. She can't speculate on other possible reasons. If the court determines there's a substantial likelihood that an objectively reasonable person would review race as a factor, the objection gets sustained. The court doesn't have to find purposeful discrimination. The court does have to explain its reasons on the record. Can't just say denied. The motion is deemed sufficient for stating a claim under the U.S. and California constitutions. An objectively reasonable person is aware of that an unconscious bias has previously resulted in discriminatory selection. Definition of substantial likelihood. Definition of unconscious bias. So here's where this statute might be useful today in a Racial Justice Act proceeding. Why? Because what this does is, this next series is identifies legislatively determined factors that may show discrimination. Now, racial, all of that other stuff. So whether any of the following circumstances the court can consider: whether the objecting party, the victims, the witnesses are members of the perceived group, whether race bears on the case's facts. You know, you get hate crimes is a big one where this is going to bear on facts. The number and types of questions posed to the panel, comparative answers of others, whether the record supports the reasons given. There can be some comparison. E is even more. A peremptory for any of the following reasons is presumed invalid unless the party exercising it shows by clear and convincing evidence that an objectively reasonable person would view this rationale as unrelated to race, and the reasons bear on the juror's ability to be fair and impartial. Now, if you're applying this on the RJA, Racial Justice Act, you don't have to limit this to juries. It just gives you a big list of factors that you might want to look at. So, expressing a distrust or having a negative experience with law enforcement or the criminal legal system. Now, this has been a big problem in the past. Why? You say, oh, but this juror, this black juror or whatever says that the police are often prejudiced, or maybe I ran into a prejudiced officer. So, and previously it's been, oh, this juror can't be fair, boot him off, judge agrees. I don't think that can be done anymore, not unless it's shown that an objectively reasonable person would agree and it's related to the case. Because why? It has been dismissive of genuine experiences. Black Lives Matter. Maybe this person really did run up against a prejudiced cop. Maybe that doesn't mean the person would be prejudiced against the prosecution or against all law enforcement officers in the current case. So you can't just dismiss a person's experience anymore by saying, oh, they had a bad experience, they must hate all cops. Can't do that anymore. Expressing a belief that officers have engaged in racial profiling or the criminal laws have been enforced in a discriminatory manner. Having a close relationship with people who've been stopped or arrested or convicted of a crime. Just because my relative, my brother, whatever, has been convicted of a crime doesn't mean I'm prejudiced against police or can't be fair. All right. And a bunch of other factors. Neighborhood, having a child outside of marriages, not being native English speaker, friendship among people of the same group. Goodness gracious. Okay. And then there's a bunch of factors that have historically been associated with racial prejudice. The prospective juror was inattentive and so forth. Those reasons are presumed invalid unless the court saw them or the person who's making the objection saw them. Yeah, I realize that juror wasn't paying attention, but that's because a bunch of specific questions were being asked of the juror on the opposite end didn't have anything to do with this guy. So take a look at those things. Now, there's a bunch of appellate standards. I'm not going to go into those right now because this isn't going to be effective for another year, but you might want to look at those later. Okay, so that's Batson Wheeler. All right, here's another big one. Court-initiated misdemeanor diversion. Now, a lot of people, in fact, the statute, the legislative history says this is a diversion over the prosecution objection, which it is. But the reason I don't call it that is because there's a lot of these diversion statutes that you can't get them over the prosecution's objection. And more important, this one is individually tailored, and the court can initiate it. Judge may, it's PC 1001.95 all the way to 1001.97. Judge may, over the prosecution's objection, offer diversion to a misdemeanor defendant. The diversion can last for up to 2 years and can have terms and programs based on the defendant's specific situation. A lot of defense counsel, they write their own program specific to the defendant, and then they give it to the judge, petition the judge for this. That's perfectly permissible under this statute. If the defendant's complied, the judge dismisses it. If the defendant hasn't complied, the court holds a hearing and ends a diversion. Now, who's not eligible for this? So this is a great thing, I think. So any PC 290 offense is not eligible. Well, that's not so good. Any domestic battery, 217.5 is not eligible. Domestic battery is not eligible. Stalking is not eligible. Here's what's good, I think. DUI is not included as a no-no. That's going to be litigated for sure. A lot of prosecution and maybe some judges are going to say, oh, well, the legislature must have meant to exclude DUIs, but it's not in the exclusion statute. So maybe DUI is included, particularly now. This is discretionary with the judge. The judge never has to do this. Well, the judge can abuse discretion, okay, but it is discretionary. So the more likely it's going to be the questionable DUIs, the low BAs and so forth that are more likely to get this than the higher BAs. Okay. The defendant has to complete the conditions, has to make restitution, but inability to pay is not a grounds for denying diversion or saying the defendant didn't comply. The defendant has to comply with other orders, stay away orders, gun orders, and so forth. On successful completion, the arrest is deemed not to have occurred. However, it can't be used against the defendant. However, it can be reported on a peace officer application. So this does not expressly require any admissions or a guilty plea. I don't think the judge can require them. The reason I really bring this up is for your non-citizens. Be careful about admissions for them, because admissions and conditions may equal a guilty plea for immigration purposes. So be careful. It doesn't say whether the court can order probation supervision. I don't know. We'll find out. Now, the terms are not required to be in writing, but goodness gracious, get them in writing or get a record. Why? Because if you don't, you're going to find a year from now, the prosecution or the judges are going to say, oh, your client didn't comply with the conditions because they didn't dot this particular I. So you want to get this in writing and say, no, it wasn't a condition to dot that particular I. All right. By the way, particularly good for this kind of thing, cases that got delayed for 6 months because of COVID-19. Judge, my client's already been on essentially a misdemeanor diversion. So you ought to just give him a quick program. All right. Prison sentences, okay, enhancement. So this is another cool one. All right, so a lot of enhancements say it's a prison term, but they're attached to a county jail felony term. This statute says that the place where an enhancement is served is the place where the underlying felony is served, even if the enhancement says served someplace different. This will work both ways, I suppose. But the point is that if your client is convicted of a county jail felony and has a prison enhancement, it's going to be served in the county jail. Okay, so let's see. Okay, juveniles, custodial interrogation. This statute did two things. Listen, I'm looking for questions on here. I'm not seeing any questions. Go ahead and ask questions through chat. All right, so about 2 years ago, a new statute said that prior to custodial interrogation, a person 15 and under shall consult with legal counsel in person, by telephone, by video. That consultation can't be waived. So that age now is increased. A youth 17 years or younger shall consult with legal counsel in person, by telephone, by video conference, can't be waived. And in B, it's W9 625.6 subdivision B, a new sentence is added. And additionally, the court shall consider any willful violation of subdivision A in determining the credibility, the believability of the law enforcement officer. The significance of that is coming up. Okay, bunch of exceptions. It doesn't apply in emergencies. If the questions were limited, it doesn't apply to most probation officer stuff. But here's the thing. What's your remedy? Well, your remedy directly under the statute is not suppression. unless it's required under the federal law. Why? There's a case called In re Anthony L. 2019. The court has to apply federal standards because of the truth and evidence provision, Prop 8. Unless the statute was passed by a 2/3 majority, the federal standards will apply. So that section does not authorize a court to exclude statements that are admissible under federal law. This amendment did pass by 2/3, but the original one is what counts, and that didn't pass by 2/3. Okay, but what about this new addition of officers' credibility? So I was looking to see if I had a separate slide on. So here's how this one works, or might work. So suppose your client says, all right, I'm not seeking exclusion under 625.6. I'm seeking exclusion because this was a coerced confession. I'm seeking exclusion because I was improperly promised leniency. Those are reasons that merit exclusion under federal law. And the officer says, oh, no, I didn't make him any false promises. Oh, no, I didn't coerce him. I said, please, please. Well, but the judge says, but you deliberately violated subdivision A. I'm allowed to consider that deliberate violation in deciding whether to believe you when you said you didn't coerce it. And the judge might not believe him. So that might be a way you can get exclusion here. All right, onward. Okay, women in jail and prison, including pregnant women, possibly pregnant women, postpartum women. This is a statute that's just shocking that there had to be a statute like this. It requires a variety of tests and services be given to in female inmates, including free feminine hygiene products, certain family planning, prenatal care, access to by pregnant inmates to doctors, social workers, community-based program. Now these are limited, but they're better than they were before. Hospital delivery with some privacy and possibly a support person. You can't use tasers and chemicals on them. Now, these things can differ a little bit, or whether the person's in prison or local jail. I do want to quote one in particular. So it added PC 3408 in prison, PC 4023.8 in jail. Okay, each incarcerated pregnant person shall be referred to a social worker who shall do all of the following: discuss with the incarcerated person the options available for feeding, placement, care of the child after birth, including the benefits of lactation, breastfeeding, assist the incarcerated pregnant person with access to a phone to contact relatives. It just says relatives regarding the newborn's placement. And oversee placement of the newborn child. Now, there's limits on this. It can't just be dictate the placement, I'm sure, but it's better than what went before. Okay, so confidential calls to prison. If you got prison inmates, this one may help you. The existing CDCR regulations permit an inmate to make a confidential call only on a case-by-case basis. This statute, 5058.7, says CDCR shall approve an attorney's request for a confidential call with the inmate that they represent. It has to be at least 30 minutes once per month per inmate per case. Whether this helps or not depends on the prison. I just completed a caseload where I had prisoners all over the state. I found that some prisons just really stingy on phone calls, and I found that others were really generous on phone calls. I'm hopeful that the ones that were generous don't use this to limit my phone calls. But if you're getting a stingy prison, pull out this statute. Okay, MCLE on bias reducing strategies. This is actually last year's law, but there was an important change that's going to affect 1 out of every 3 of us. And I think it's a cool little statute. This statute, it was effective for MCLE for what our education requirement wasn't effective until we had to report in 2023. Now it applies also to those who have to report in 2022. So it says, the state bar shall adopt regulations that require training on implicit bias and the promotion of bias reducing statutes. It's not just how to recognize it, it's what to do about it. And it's race, ethnicity, gender identity, sexual orientation, socioeconomic status, or other characteristics that undermine confidence in the legal system. Okay, so, well, socioeconomic status, poor people, that's who all you appointed council people, including me, that's who we represent, poor people. And so you can do something about bias against them, that you got to get trained about it. What about rich people? How much justice can you afford? I guess we got to get trained in bias against rich people, in how to cure that in the legal system. I can guess how to do that. Okay, juvenile justice realignment. So there's a history to this one. Just briefly, so last July 2019, a new law required the transfer of DJJ, Division of Juvenile Justice, to a brand new Department of Youth and Community Restoration in Health and Human Services, to be accomplished by last July 1st, 2020. And then COVID-19 hit halfway through that transfer. An executive order extended the compliance date to July 1st, 2021. And then this bill adjusts that plan again. It's no longer a required, it's now an intent, a hopeful one. Okay, so from the Legislative Council, this bill, as of July 1, 2021, now prohibits most further commitment, not all, but most further commitments to DJJ. It requires that all wards who are already there by July 1st, they remain in DJJ's custody until discharged, released, transferred. This bill declares the legislature's intent to close DJJ through shifting responsibility. Commencing July 1, 2021, it establishes the Office of Youth and Community Restoration and HHS to administer these provisions and to support this transition. Now, what I'm hoping is that getting it out of CDCR and into HHS will change the culture. We'll see. I hope that's what it does. But there's going to be a lot of transfer to counties. Under the original schema, it was mostly to this new institution and only a little bit to counties. But right now, it might entirely be to county. It's certainly largely to counties. Now, if there's any juvenile experts out there who have more recent or more inside information, put it on chat. I'll read it to the group. All right, it establishes grants to counties. There's a juvenile justice realignment block grant subject to funding. Funding's a little bit tight right now, to provide for county-based custody, care, supervision of youth who are realigned from DJJ or who would otherwise have been eligible for DJJ. So there's going to be a lot of planning going on between now and then. You can take part in this, although I don't talk about it here. All right, so there's some lowering of the maximum age in juvenile court, but it can continue still to 23 and 25, depending on the offense. But there's some lowering. So you want to read the statute 707 and those series. And there's a lot of other changes by this bill. It's SB 823, Statutes of 2021, Chapter 337. This is one of the few statutes in this series that I don't have the amended statutes here because there's a zillion of them. They are in the written materials, or you can look this up in the original for yourself. Okay, peace officers, use of force. There's like 4 of these, although I number them 3. Adds, and this is in the government code. It's not going to be in your penal codes that you get from Lexis and West to just say penal and evidence codes. It's in the government code, 7286.5. A law enforcement agency shall not authorize the use of a carotid restraint or chokehold, and those are defined in the statute. Number 2, again, in the government code. Where do I find the government code? Well, online, basically. Okay, so, and this is subject to a legislative appropriation. It says, a state prosecutor shall investigate officer-involved shootings resulting in the death of an unarmed civilian. It doesn't say that this has to be a non-suspect. So it can be a suspect, unarmed civilian. The AG is the state prosecutor, unless otherwise named. The state prosecutor can investigate, must submit a written report, put it on the website, and can initiate and prosecute if warranted. Starting July 1st, 2023. I don't know why this is so far in the future. The Attorney General shall have a police, maybe it's the appropriation that's required, a police practices division on request of a law enforcement agency will review deadly force policies. Okay, so.
Hey, Garrick, here's a question
Yes.
regarding,
Yeah, okay, let me see.
so
The
it
problem
hasn't
is that
been,
many of the DJJ higher-ups are likely to be simply shifted. Yes, that is a problem. So this has to do with this juvenile justice and the realignment. That's a problem with this bill. There's no doubt about it. This is an intent bill. It's dependent on funding. It's dependent on these grants, and it's probably dependent to some extent on each county. So my advice is to monitor this kind of thing closely. When you get a new juvenile case where it might be a case that would have gone to DJJ, I'd start looking into these. I'd contact your probation department right away and find out where this county is on the realignment, and handle your case accordingly. That's the best I can do on that question, I think. I'm glad you called my attention to it.
I then had another question regarding the use of force. It talks about against individuals who are found to be unarmed.
Yeah.
Do you have any idea how it's going to be when an officer thought someone was armed? So often that's used as a justification. Is that just afterwards the individual was not armed, or any thoughts yet? Obviously, it's fairly new.
Yeah, the classic is that the individual had a cell phone and not a gun. And officers get trained on this kind of thing. I've seen some of these training flicks. They have to decide in a split second, faster than one can think, whether when the suspect turns around and there's something in the hand, that is it a gun or a cell phone? What the statute says is an unarmed civilian. The statute does not say an unarmed civilian who everybody knew in advance was unarmed. It just says unarmed. So that's going to obviously be a big point of investigation. Did the officer reasonably or unreasonably think or contend that the civilian was armed? And this is going to be developed over time. That's one of the reasons that some of this stuff is delayed.
Thank you.
Any other questions before I move on here? Whether I've gone through, statutes I've gone through, racial justice, whatever. Okay.
There are no others in the chat, so we'll just wait for people to reach out.
Great. Okay, so let's see. I did number 3. Oh, number 3. Okay, so this requires that during their post-training, police officers, requires that peace officers be evaluated by a psychologist or a psychiatrist for bias against race, ethnicity, gender, nationality, religion, disability, sexual orientation. And the commission, post-commission, police officer standards and training has to update regulations and screening materials to identify explicit and implicit bias against race related to emotional and mental condition evaluations. It requires every department or agency that employs peace officers must make changes in job descriptions to de-emphasize paramilitary aspects and place more emphasis on community interaction and collaborative police solving. This seems to me like a genuine effort to really change cultures in the police departments, and we'll see how that works, but it's a nice statute. Okay, this one I could have called use of force, maybe should have. So it lets the Board of Supervisors or a vote of the residents, a county initiative, can create a sheriff oversight board. So sheriff, that's the county. It doesn't talk about police oversight boards. Maybe that's coming, I hope so, of civilians to assist supervisors in their duties to supervise. Oversight board can issue subpoenas for a variety of reasons. It also, I think this is really basically alternatively and not in addition, but who knows, it lets the Board of Supervisors or residents establish an inspector general to assist with their duties to supervise, and the inspector general can also issue subpoenas. So hopefully that will help. All right, this is the only solid evidence provision in this year's new laws and it is not in the evidence code. And what it does is it says that a person who is a victim or a witness to this list of serious, mostly sexual offenses, serious sexual offenses, who at the time of being a victim or a witness unlawfully possessed or used a drug or an alcohol, that's not admissible in a separate prosecution to prove possession or use of that drug or alcohol. The reason for that is to encourage victims and witnesses to come forth. It does not stop that use or possession from being used in your own client's trial. It can be brought up then, it's not excluded. And the fact that they got immunity, well, isn't it true that you possess this drugs and alcohol? Are you testifying because you know you're immune in the next against being prosecuted in your own separate case? That's still all admissible. And that one, it adds PC 1324.2. Where's that one? Well, that one's close to the statute where the prosecutor gets to offer immunity to witnesses, 1324. So if you get one of these serious sex cases, a victim or a witness had drugs or alcohol, look at that statute, see what use you can make out of that one. All right, false reports and harassment. This is what this one does is it says it asks at 653 why. Okay, first of all, you got to wade through other 653s to get to Y. Then you have to get past A to B, C, and E2. Outlaws knowingly allowing the use or using the 911 system to harass another person, it's a crime. For a first violation, it's an infraction. For a second one, it's a misdemeanor, and it goes up. And see, it's worse to knowingly allow this or to use it to allow in certain racial and terror and hate crimes and terrorist crimes, 422.55, 0.85, then it's a bigger misdemeanor with more punishment. And there's an interesting exception to it. It does not apply to 911 calls by a person with an intellectual or mental disability. That makes it difficult or impossible for that person to understand the potential consequences of their actions. Interesting little exception. You know where that one mostly might come into use is if your client's incompetent to stand trial, or might be. Okay, so here's a COVID-19 statute, anti-price gouging and epidemics. All you really need to know about this one is if your client gets charged with price gouging, look up this statute, which in the past did not, by its terms, extend to pandemics and epidemics. It now does. And in addition, the types of offenses that it covers, the types of price gouging that it covers is broader. The length of time that is covered is also longer. Okay, 290s. So there's exemptions there passed. Many of you remember the old Hofshire case that exempted certain crimes, sex crime, in addition to unlawful sexual intercourse, 261.5. The similar statutes, oral copulation by consent between a minor, 17, 18, and a young adult, said they didn't have to register. Then the Supreme Court said, oh no, we changed our mind, now you do have to register. So this gets back, tries to undo that, restore the status quo ante. The court, however, can still order discretionary registration under 290.006. Is it retroactive? Maybe, try it. Okay, now, three-tiered PC 290 registration becomes effective this year. Now, those of you who heard me do this for the CACJ conference, there's new material here. Open up your ears. This is an old law. It's a 2018 statute that became effective finally on the 1st of this year. In the first place, it's been amended again that we're going to go into. There's now 3 tiers. The people who are in tier 3 mostly cannot end registration. There's one exception. Tier 2 mostly can, and these are the most serious crimes. Tier 2, they're the intermediate crimes. And they mostly can end a petition registration after 20 years. There's an exception that lets some group after 10 years. Tier 1, the least serious crimes, mostly misdemeanors, can petition to end registration after 10 years. Now, for 602s, if you're in Tier 2, it's 10 years. If you're 602s, if you're in Tier 1, it's 5 years. But now all of these tiers, they're in PC 290 subdivision D. You want to make sure you're using this year's code. If you just got last year's code, there's usually 2 versions of PC 290. One that comes first with larger print, which is that year's effective one. Usually there's one that comes after in smaller print or maybe italics. That is this year's one. So if you have to use last year's code, go look for the second version and you'll find 290D. Here's the big deal. There's 2 big deals. First, no one's registration is guaranteed to ever end. It's discretionary. So don't tell your clients, oh, you will end registration after 10 years. Not true. Might be able to end it after 10 years. Okay. And secondly, in deciding which tier your client is in, start with Tier 3. Don't start with Tier 1. Why? A person might be in 2 tiers. If you start with Tier 1 and you say, oh, my client's in Tier 1, I don't need to look at Tier 2 and 3. You might be committing malpractice because your client might be in Tier 3. And you say, oh, you can petition after 10 years when in fact they can't petition at all. So start with Tier 3 and work backwards. Now, they got to complete this period of time. Well, that's not straightforward either. Read subdivision E to see how that one is calculated. Okay, now this is new to the CACJ people. I didn't talk about this. So the California Department of Justice has issued a frequently asked questions. California Justice Information Services Sex Offender Registering, CSOR, frequently asked questions. And you see this is way too small to read unless you got a big computer screen. So you're gonna have to get this on the website. Beginning January 1st, 2021, etc. But the last one, beginning January 1, 2022, registrants on the website is rejiggered a little bit. It goes by tiers. So you want to look at that one. That one's coming up. And you want to look at these. Now, here's the big deal, the biggest deal about this. It says that the tier is determined by the Department of Justice, not by the court, not by you, by the Department of Justice. And your client can ask what tier the Department of Justice has put them in when they register, can say, hey, I want that letter from DOJ. They may need to bring in these facts to say they get it, okay? Why is this? It's because registration is always, the tier is also always determined by the score on these bloody Sriracha tests, you know, the tests that sex offenders have to take to say what their risk is. Okay, so that's a big deal. That wasn't in the CACJ. Okay, we're running out of time. This is a little more about that CSOR facts. How to petition to end registration. This is 290.5. Here's what I want to say about I'm getting just about at the end here, and time is just about over. Here's what I want to say about 290.5. It is written inside out and to some extent upside down and backward. Why is it written that way? Well, could it be because the authors wanted to make it as hard as possible to figure out how to end your registration? Far be it for me to accuse them of that. But you got to read, this is one where you really do have to read the whole statute to figure it out. There's a lot of ins and outs to this one. Okay, there's A and 3 and 4, blah, blah, blah. Here's the really important part. There's Judicial Council drafting forms. They're called CR 415. There's one called information. They are not officially released. I would nonetheless get them off the, oh, by the way, you can't petition to end registration until July 1st, 2021, and not even then your client's birthday after July 1st, 2021. So this is not even effective yet. And these forms are not effective. But when the time comes to petition, use the forms, read the info. It makes it simpler. It makes it easier to understand. You don't have to depend on my material or even that bloody statute. Okay, then what else? So track device tracking on your car. Have to do a search warrant, including software. They put it on your cell phone, on the car's computer. Length of parole is reduced down to 2 years generally. If the person completed drug treatment in the prison and they voluntarily enroll in qualified drug treatment, they can get their parole time reduced. Lastly, elderly parole. The time is reduced. If your client's an old guy, over 50, done 20 years in prison, check to see if they can apply for elderly parole. All right, thank you. I'll stay for a few minutes to ask any questions if they'll keep the thing open. Those are new laws for this year.
Thank you so much, Garrick, for that run through. This is where we would all applaud. I hope that everyone is giving a round of applause where they are.
I can hear that applause.
Thank you so much. The materials for the event, as Ann mentioned, will be available to everyone. If you have any questions, concerns, or if they're unopenable for you, please don't hesitate to reach out. And thank you so much.
You're welcome. Well, something comes up. Thanks to all. Okay.